issues on the advisory opinion. I think that it was already sent on your group WhatsApp. Thank you so much. So this is our statement, the written statement of the African Union, in which you can find all the genesis and how we build the case in front of the court, plus another part, what is the summary of all our findings and the implication of that when we come to the national courts. So this is a little bit what I needed to say as introductory remarks. As I'm saying, one of the most important conventions is the 1968 convention, and I will go directly to that to highlight the importance and the objectives and the scope of this convention. I will go to the slide 15. So this is our African Convention on the Conservation of Nature and Natural Resources. All the time pay attention with the dates. We are in 1968, so that means this is not very updated. However, it constitutes as one of the most important and pivotal moments in the continent's environmental history, as it is setting the stage for how African nations approach conservation and sustainable development. So in this convention, we'll see what are the objectives, provisions, and key provisions, and what is the broader significance it is holding for regional cooperation and subsequent legal frameworks. And you will find that most of the aims and the objectives of and the scopes of this convention will be highlighted in the other conventions. So this is the only one where I will go in deep. The other ones I will go very fast. So this can be considered as the main important convention in the issues of environment. It is a strong emphasis on conservation of natural resources, specifically soil, water, flora, and fauna. Why it is important? Because Africa's ecosystems are diverse, and they provide critical services that support both human livelihoods and ecological balance. Soil and water, for instance, are fundamental to agriculture, and this remains the backbone of many African economies. And the degradation of those resources not only threatens food security, but also they disrupt the delicate balance of our ecosystems. And the flora and fauna are not just about the wildlife we see, they are also integral to the health of our ecosystems. Plants, animals play key roles in processes like pollination, seed dispersal, maintaining the structure of the food webs. The convention recognizes also that conserving these resources is really essential for maintaining the overall health of the environment. So in this convention, you will find the idea of sustainable development. We are in 1968, so this means our African continent and our African countries are just beginning to build themselves, economically speaking. So we have this need to balance two issues, the environmental issues, but also at the same time the sustainable development. And this is what you will find on the case. All the case is built on this balance, how you can encourage the sustainable development, but at the same time you are protecting environmental issues. So the convention is trying to align with sustainable development, and this treaty advocates for the rational use of natural resources. And this is a concept that underscores the importance of meeting present needs without compromising the ability of future generations to meet theirs. And this is not a theoretical idea, it's a practical framework that guides how countries utilize resources like forests, like water, like minerals, and it is also calling for development that is both economically viable and environmentally sustainable. And this is particularly significant in our African context, where development pressure are high, but so too are the risks of environment degradation. And by embedding sustainable development into the treaty, the convention ensures that conservation efforts are not seen as obstacles to development, but as essential components of it. When you go to the Article 5 of the convention, these are key provisions on issue of soil and water conservation, and through processes like erosion, pollution, desertification, this poses a serious threat to agriculture, and this provision calls for measures to protect soil from these threats, ensuring its long-term viability for agriculture and other issues. We have also the water conservation in this article. The Article 6 is about fauna and flora, And it is also something that is protecting particular focus of these species. The loss of biodiversity is a global issue, but it is actually felt in Africa, where many species are at risk due to habitat loss, poaching, and climate change. And I'm sure here in Tanzania you have the same problem as we have in a lot of other countries where we have rare species that are under threat. And these protected areas are not just about saving individual species, but they are about maintaining the integrity of entire ecosystem. We have also the Article 8. This is very important one. It's about the EI, and this is the environmental impact assessments. In this Article 8, this is crucial tools for ensuring that development projects do not harm the environment. So the idea is that before any major project is approved, it is a dam, it is a road, or it is an industrial facility, or it is extractor of minerals, we need what is called environment impact assessment to be done. And it should be conducted to assess its potential environmental impacts. And this process is not a bureaucratic formality. It is a vital step in protecting our natural resources. And this helps identify potential environmental consequences early in the planning process, allowing for the development of mitigation strategies that can prevent or minimize harm. And this proactive approach is essential for balancing development needs with environmental protection. This is very easy to put it in a convention, to put it in an article, but when it is about implementing it, you may know it is about preventing and controlling pollution. And pollution from industrial, agriculture, and urban activities is really posing significant risks to both ecosystems and human health. And this Article 9 is emphasizing the need for measures to reduce pollution, including regulations on emissions, waste management practices, and the safe disposal of hazardous materials. In many of our countries, pollution is a growing problem, particularly in rapidly urbanizing areas. And by including pollution control in the convention and the treaty, acknowledges the need for a comprehensive strategy that not only address the sources of pollution, but also protect vulnerable communities from its impact. And you can find also another article, it's the Article 10. It is about the promoting sustainable agricultural practices and the conservation of forest resources. And the provision encourages the adoption of techniques that maintain soil fertility, reduce deforestation, and enhance reforestation efforts. Sustainable agriculture, but that is not just about producing food, it's about doing so in a way that preserves the land for future generations. Also, sustainable forestry practices are essential for maintaining the health of our forests, which are vital for regulating the climate, protecting biodiversity, and supporting livelihoods. So now, what is the significance and the impact of this convention? This is not only a set of rules, it's a framework for regional cooperation. The word cooperation is very important. Environmental challenges do not respect national borders. I told you that at the first site. And in many of our African countries, most pressure issue are transboundary in nature. And this convention encourages African countries to work together, to share knowledge, and to coordinate their efforts to address these common challenges. And this collaborative approach is crucial for effective environmental governance. We have also foundation for subsequent legal instruments. As I'm saying, the 1968 Convention will lead the groundwork for subsequent environmental agreements and policies in Africa. And it set a precedent for the development of more comprehensive and updated legal instruments that reflect evolving environmental concerns and international best practices. For example, we'll go through the Bamako's Convention on hazardous waste management and the AU's various initiatives on climate change. And all of them, they are building on this established 1968 convention. And these latter agreements have benefited from the foundation laid by the original treaty, which provided a solid legal and institutional framework for environmental protection in Africa. We have also the issue of promoting awareness and capacity building. And beyond its legal provisions, this convention has played a crucial role in raising awareness about the importance of environmental conservation and sustainable resource management. And this focus on awareness and capacity building is vital for the long-term success of environmental initiatives. And by educating and empowering individuals and communities, this convention helps ensure the environmental protection that is not just a government mandate, but a shared responsibility. So as a conclusion for this, the regional and the awareness, I already tackled that. As a conclusion for that, this convention is a pioneering step towards environmental protection in Africa. It is establishing essential principles and provisions that continue to influence environmental governance in the continent. As I'm saying, we are in 1968, and that's why this convention was revised years after. It was in July 2003, and yes, the new convention that entered into force in 2016. This convention also is a landmark in our continent's effort to protect the natural resources, and it does reflect a deepened commitment among member states to cooperate on environmental issues. Now, yes, this is normal that it is a natural evolution of the Alger Convention of '68, and it is giving more deepness in the obligation of African states in response of emerging environmental challenges. So this revised one is already entered into force as it is ratified by 17 countries, and it is representing a collective knowledge and acknowledgement of the urgent need to address environmental threats facing our continent. What is the significance and the development, and what are the most important issues that are behind the Convention's adoption? Number one, the recognition of ongoing dangers threatening Africa's natural resources. Number two, the necessity of sustainable use, demanding both individual and collective action. Number three, the alignment with continental frameworks like the Lagos Plan and the, of Action, and international instruments like Rio de Janeiro Declaration and Agenda 21. And fourth, the commitment to furthering global principles from Stockholm Declaration and the World Charter for the Nature. So what are the objectives and what are the scope and the guiding principle of this convention? So this is in the Article 2 of the convention that aims to enhance environmental protection and foster the conservation and sustainable use of natural resources and harmonize policies for development that is ecologically rational, economically sound, and socially acceptable. And the scope of this convention is equally comprehensive, applying to all areas within the limits of national jurisdiction of any state party, and extending to activities beyond these limits if they fall under a state's jurisdiction or control. In fulfilling their obligation, the member states are guided by principles that reinforce the right to satisfactory environment, the duty to ensure the right to development, and the necessity of balancing development and environmental needs in a sustainable and equitable manner. What are the key features of this revised convention? The revised convention expands the obligations of member states compared to the Alger Convention of '68. It not only mandates the adoption of preventive measures, but also incorporates the precautionary principle and ethical considerations, integrating traditional values with scientific knowledge. And the enforcement and monitoring mechanism also is one of the critical advancement of it. We need some monitoring and implementing mechanism and enforcement mechanisms. And at the regional level, this convention mandates interstate cooperation and reporting mechanism to ensure proper implementation. This is the Article 12 that obligates states to cooperate not only among themselves, but also with other states and international bodies, enhancing the effectiveness of their environmental policies. The convention introduced also Conference of State Parties at its decision-making body, tasked with promoting compliance, reviewing reports, and facilitating the exchange of information. However, it is crucial to note that this conference has not been fully operational since the convention's entry into force, highlighting a significant gap in the convention's implementation from it. While I'm speaking about the gaps of these conventions are the following. The environmental principles. We have, you remember what we said at the first course. We said that one of the main important principles in environmental law is polluter pays. And this principle, it is silent. here in the convention. It is true that this convention incorporates many of the environmental principles, however, it is silent with the polluter pays principle. And the second one, you remember, the CDRB principle. This is the principle of common but differentiated responsibility. This is also critical for equity and justice and climate justice, and we do not find it here in the convention. Also, the issue of non-renewable resources. This convention focuses primarily on renewable resources, with limited provision of non-renewable resources, which are only explicitly mentioned in the Article 13. We have other issues on intellectual property rights and issues on enforcement mechanism. Again, all the conventions, the international law, and specifically on human rights issues, have this problem of lack of detailing enforcement procedures and penalties for non-compliance, such as failure to submit reports, and this gap weakens the overall effectiveness of the convention. We have also the issue of operationalization of the Conference of the Parties that is also delaying, and this is political will. As a conclusion for this convention, we can say that this revised African Convention on the Conservation of Nature and Natural Resources of 2016 represents a significant step forward Africa's environmental governance. It builds on the foundation of the Algiers Convention, expanding obligation and introducing new mechanisms to address contemporary environmental challenges. However, and to realize its full potential, the gaps identified must be addressed, particularly the operationalization of the Conference of Parties and strengthening the enforcement mechanism. Let's go now very quickly to other conventions. As I'm saying, the first one on the natural resources is the main important, but we have a lot of other legal instruments on specific domains. And this is one of them, very important one and very well known. It is called the Bamako Convention on the ban of the import into Africa and the control of transboundary movement and management of hazardous wastes within Africa of 1991. There is a historical background for that, and it was in the 70s and early 80s that were marked by growing global awareness of the dangers posed by the transboundary movement of hazardous wastes. Industrialized nations, in their search for cheap disposal methods, increasingly looked to developing countries, many of them in Africa, as potential sites for hazardous waste disposal. This practice raised serious concerns about the environmental and health impacts on these vulnerable nations, which often lacked the infrastructure to manage such waste safety. And in response of that, the international community adopted the Basel Convention in 1989. This is under United Nations. And this aimed to regulate, but not to ban, the transboundary movement of hazardous waste. However, during the drafting of the Basel Convention, a rift emerged between developed and developing countries, and African nations in particular pushed for a complete ban of the import of hazardous wastes, and this is a position that was not fully embraced by the more industrialized states. That's why in May 1988, our African Union, or our Organization African Unit at that time, adopted a resolution 1153 that declared the dumping of nuclear and industrial waste in Africa as a crime against the continent and its people. And this was followed by the resolution 1225, which called for the drafting of an African convention to prohibit the import of hazardous waste and establish a framework for their management within Africa. And this was the Bamako Convention, and it is built as a response to the failures of the Basel Convention. What are the key features of this Bamako Convention? And before I go there, I just need to open a parenthesis about the practice. And I remember very well in Tunisia, it was in 2017-18, when Italy sent a boat with nuclear waste to Tunisia without preventing. I remember another story about France sending cargoes in airplanes of waste to be put in the desert of Algeria. This is the examples that I remember. But you can understand how dangerous and what is the impact for environment is this Can you imagine nuclear? You imagine and you remember the one who are familiar with Chernobyl crisis, the documentary showing for years and decades the implication of Chernobyl, even if the site of Chernobyl was completely closed for citizens, for people, but the diameter, kilometers on Chernobyl, there is still problems on generation, even on babies, etc., etc. Can you imagine that this waste, without any consent with the African countries, and maybe you can give examples from your own countries, you can imagine what is the implication for our environment, for our health, for our, when you have the waste of nuclear energy, that means you will have no plants, you will have nothing, no fauna, no flora, no healthy environment, and no one knows where they put them. They just put them in secret places and no one knows. They dig in the Sahara or in the ocean or whatever, and these countries, they do not care about the developed countries and the human beings and our people. So the most important is just to put this waste as far as possible. And this is also the implication of World War II. At that time, most of our countries are colonized by some countries like France, UK, etc. And these countries use the same. Without any prevention, without any consensus, they come, they put their waste, nuclear ones, this is very dangerous, and they go. So this is something that I needed to highlight and for you to understand why Bamako Convention is very important. And on the basis of that, we are not limiting, we are banning in Africa. And this is a little bit the different articles in this convention. This convention applies to a wide range of wastes, including those hazardous by nature, those defined as hazardous by the domestic legislation of the state, of export, import, or transit, and radioactive wastes. Notably, it includes household waste as a category excluded under the Basel Convention. And this broader scope reflects Africa's comprehensive approach to waste management. Article 4.1, it is here unconditionally prohibits the import of hazardous waste into Africa from the non-contracting parties, categorizing such imports as illegal and criminal. Article 4, paragraph 2 also bans the dumping of hazardous waste at the sea, including incineration and seeped disposal. This prohibition extends to all internal waters, territorial seas, exclusive economic zones, and high seas under the jurisdiction of state parties. You have also the precautionary measures in which the convention adopts obligations that the states take preventive measures to avoid pollution and promote clean production methods. And this is a significant departure from the Basel Convention, which does not explicitly include the precautionary principle. We have also the pollution prevention. Bamako Convention emphasizes adoption of clean technologies throughout the product life cycle, from raw material extraction to disposal. And this approach is forward-thinking and aiming to prevent environmental harm and its source rather than merely managing its consequences. We have also obligations regarding waste generation and management, and we have also the issue of enforcement mechanisms and monitoring mechanisms. So we have the competent authorities and the dump watch issue. That means that the state parties must designate competent authorities and establish a focal point for the convention's implementation. Additionally, the convention introduced the concept of dump watch to monitor and coordinate activities related to hazardous waste management, a feature that is not present in Basel Convention. We have also the issue of intra-Africa cooperation. We have the criticism and challenges that I need also to raise and to highlight. We have some ambitious provisions, such the requirement of clean technologies that are seen as unrealistic for many African countries and states, which may lack the financial and technological capacity to implement them. We have also the broad scope of application. This convention broad definition of hazardous waste could lead to industrial opposition. total ban, I'm audible, total ban on imports, the unconditional ban on hazardous waste imports has been criticized for potentially infringing on the sovereignty of African nations by limiting their ability to manage and to benefit from certain types of waste if they have the capacity to do so. We have also lack of liability and compensation procedures, because even if it includes provisions for strict liability, it does not establish a comprehensive liability and compensation regime for damage resulting of transboundary movements of hazardous waste. And this gap has been addressed in the Basel Convention through the Protocol on Liability, but a similar mechanism is lacking in Bamako Convention. Now, as a conclusion for this one, these are the criticisms. And coming now to the conclusion, this Bamako Convention is a powerful testament to Africa's resolve to protect the environment and the people from the harmful effects of hazardous waste. It goes beyond the Basel Convention by imposing stricter controls and adopting a precautionary approach to pollution prevention. However, as I'm saying, the convention is really to be effective. It is essential to address the criticism and challenges it is facing. Maybe also it is not only about convention. Again, there is the issue of corruption. Sometimes, even if this convention exists, there is still some interferences, some practices that are illegal and irregular, and I will give you some when I come to AFCON. This is another story. The last maybe rows of conventions and legal instruments is about the Banjul Charter that everyone knows. You have, I think you had already a course on human rights, international law on human rights, and the Banjul Charter, or the Charter of Human and People's Rights, has already some environmental provisions. And as you know, there is a key provision in Article 9. It's about right to information and expression. And we have broader rights framework. This charter is notable for its holistic approach to rights. Remember that when the first day, I've done some comparison with other legal instruments on human rights, with other continental and regional spaces, and I gave the issue of inter-American and European conventions or charter on human rights. Ours was adopted in 1981. That means that we already covered the third generation of human rights, specifically the collective rights. And if you can see very well that the name of our charter is all the time you put people's rights. Even here our court is called the African Court on Human and People's Rights. The Charter of Banjul is about human and people's rights. The Banjul Commission is about the Commission on Human and People's Rights. That means that in Africa, we care about individuals, but we care also about people, about groups. And we care about solidarity, and we care about the last generation of human rights. The last is the fourth. It is not only already included at the era of technology and ChatGPT and AI. This is another story. But at least the third generation is implying the environmental issues. So it introduced the concept of collective rights, as I'm saying, and it is particularly relevant in the African context where community and group rights are often as important as individual rights. And this approach reflects the interconnectedness of rights and the understanding that human dignity is upheld not just throughout individual freedoms, but also through the rights of indigenous peoples under the Charter, but also set a precedent for how such cases should be handled in the future. And it highlighted especially the case. I will not go through the details, but at least I will highlight the merits of the case. The court's findings on the merits of the Ogier case were significant. It found that Kenya had violated several rights under the Charter, including realizing the concept of people's rights within the African human rights system, particularly for indigenous and minority communities. And when we came also to another case, the Serac versus Nigeria, this is another case that is also very important, and I think Shell at that time, is now Vivo Energy, paid a lot of money because of this case. And it was built also, it's about oil production activities, and it was against the Nigerian government and oil companies for environmental degradation and human rights violation in Ogoniland. So they built on the Charter of Banjul. What are the challenges of the Charter? Despite its strength, This is Nigerian case. We go to the challenges. So we have some challenges and some weaknesses in the charter. We have ambiguities in some provisions. Some are broad and vague, particularly those related to collective rights. We have exhaustion of local remedies. We have problem of enforcement mechanism. While the charter establishes the African Commission and the court, enforcing their decisions remain a challenge. Many states are reluctant to comply with the rulings that they perceive as infringing or on their sovereignty, and there are limited mechanisms to compel compliance. In general, human rights, I said that in the first course, we are in Africa, so democracy, rule of law, human rights are taboo, and we are still, as Africans, still reluctant with the issues on human rights. Can you imagine that the charter at that time, in 1981, didn't speak about a code? It is something that came after. In the charter, we had only the Banjul Commission. I had a question on what is my position on this. So I said that as legal counsel, we have nothing to do with the member states. International law is all about sovereignty and about voluntary. So when we have a court on human rights that is giving decisions, and these decisions are to be expressed, they should be binding, go to the website of the court. It is something available. And because of GIZ, I think they've done a lot of work with the court here, and they've done a statistics, and it is very well done in the website. You will be surprised to see that more than 85% of the decisions of the court are not implemented. Can you imagine that we have a court that is giving decisions, including my country, I'm speaking about Tunisia as well, that we have to comply with? Tanzania, Kenya, these are a lot of cases for human rights issues. And not only the countries do not imply and do not implement, but also withdraw themselves from the wonderful mechanism that is called the Article 36, paragraph 4, that give the opportunity to civil society and to individuals to come here to the court directly. So there is a lot of withdrawal, including Tunisia, Tanzania, Rwanda, etc. This gives you an idea. If all the time I'm doing comparison, it is not because the European Court or the Inter-American Court on Human Rights is a sign of success, but it is inspiring, and it is a mentality. Human rights issues is a mentality. We cannot come to an issue like Inter-American Court, European Court, where their decisions are 99% implemented. Here in Africa, we cannot do that without generation of mentality transformation. So human rights issues is very sensitive again, and the people here in the court, including the judge that are there in these seats, are really heroes, and we are courageous people. And I can tell you more. I have a lot of friends because I was in an organ, and I know Banjul Commission, and these people are not only heroes, but can you imagine that they can be declared as persona non grata in some countries, not to come to do the monitoring and to see. They are doing reports. They're just human beings like me and you, and they are elected commissioners. All that they have to do is reports annually. Can you imagine that countries sometimes, to stop the work of the Commission of Banjul on Human Rights, will declare them persona non grata? That means you are not allowed to enter even in our country. So this is the realities of Africa. We cannot be blind on that. Environmental issues is one of the last priorities for Africa. This is also something that I can say because of my experience and what I can observe. However, we need all the time to begin little bit by changing our awareness, number one, by knowing about the framework, the mechanism, how we can do it, and after that we will try, when as lawyers, the first reflex that we know in our universities is to be criticizing all the time. We need to see things in an eye that with comparative studies, okay, this is good, but we can build on it. We can reinforce the mechanism. We can update the convention on the basis of the context. And you know all that the definition of the law is already a response to the evolution of the society and its needs. The law is not Quran, it is not sacred, it cannot be forever. It will evaluate. That's why We have a text in the 60s, in the 80s, in the 90s that should be evaluated and put in a way that can resolve the recent problems that were not there in that time. So that's why I think we have all of us again and again. There is a message and a vision behind this Kilimanjaro Academy. We are not here only to speak law and to speak text and to speak legal framework. We are here to open our eyes and to be brainstorming people that will go to your countries. You are our ambassador. Number one for this issue of integration. We know that there is a legal framework at the regional level that can inspire our national one. Or the inverse. If at the national level you are very advanced, you can inspire the regional ones to be updated, you see? So cooperation, we do not enough. We are cooperating with Chinese, with France, with the USA. We do not cooperate with each other. And just the first course, the first day, when I listened to all of you, you have wonderful experience on environmental issue that can be fruitful and very interesting. We have our local mentalities, we have our local traditions and solutions coming from Singapore, coming from Japan, but sometimes cannot be successful in our land, in our continent. But when it comes from Madagascar, it comes from Libya, it is more, feasible in our traditions, in our comprehension. So I think this issue of cooperation, this issue of how to do the work together in a way that we can reinforce our mechanism and better it and update it, we have still a lot of lack. And I'm sure that there is a lot of people here, even if they are lawyers, they do not know about this legal framework. This is just from environmental issue. When you are with other professors, you are discovering other domains where we have wonderful instruments that are, again, not very well known. And I will tell you more when I come to the environmental fora. I know that in Ethiopia it will be COP 32 in 2027. The next year. This year it will be in Turkey, as I'm saying, COP 31. The COP 32 will be in Ethiopia. However, before that, we've done a wonderful climate change and environmental fora. It was a ME summit in Ethiopia in the last October 2025, and 55 member states were there, and all of them, they took the floor to put in advance what they did in their countries. But all these legal instruments, I didn't listen too much to people knowing our legal instruments. Number one, we were in November 2025. Remember that in my PowerPoints, I put you something very important. I told you don't forget the landmark advisory opinion of the ICJ, that you have to build on it, because it is really speaking about the rights of the global south, and especially Africa and the developing countries. No one, not a single one from the leaders, from the people who are more in this domain of environment. It was 3 days fora, international one. It was something huge where everyone came, where we have a lot of side events. Not a single one, I was everywhere, not a single one raised the issue of ICJ advisory opinion. That was in July 2025. So it was just 2 months before. This means that people are not aware about the evolution, the development, the tendencies, the new tendencies in environmental issue, how we can put in advanced principles, how we can take the moment in advance and build on the momentum. Again, when you have time, I send to you all the documents related to our, and by the way, see how many African countries went to The Hague to speak about environment, while all of us, without any exception, the 55 member states, we are all, and all of you can testimony on that, we are having a lot of, I said that in the first day, of problems of climate change. We never saw that, the weather, the hot weather, or the extreme weather, or the deforestation, etc. Yes, our governments can be responsible of some. However, most of it, and I show you the map of Africa that is red, while we are not the one responsible of the emission of the gas atmosphere. However, we are just victims of this environment. And the advisory opinion of the ICJ was very courageous and give you the issue of reparation. It's very important. We have to build on that. If we do not have the skills, the people who do that, we can be silent, and future generation will come and tell us, why were you silent? So I remember that it is not more than 9 countries who went there, specifically the islands, Mauritius, Comoros, Seychelles. They are very, very interested with the issue. There was Sierra Leone, I remember Cameroon, but there are really some 8 or 9 member states. That's why AU, African Union, has a voice, and the voice of the legal council who represented the 55 member states was very important. So if other countries has not the opportunity, the possibility to go there, at least African Union was very important as an organization to speak about environmental issue, to speak about the differentiated responsibilities, to speak about precautionary principle, to speak about international responsibility, and this is a whole course, reparation and due diligence, and all these issues are very interesting. You have the details, and I will show you the picture of the team. Makan Mbengue is one of the corner of these statements, and the oral one was very well adapted by the judges, and they built really on some of the decision or of the paragraphs was very courageous enough for our member states to go far. I think again the observation that I'm making is that we do not have enough specialists in these issues, and it's a pity. When we've done our workshops, we were trying to find people from Africa who can give the plus value in the knowledge on how we can do reparation on the basis of advisory opinion of the ICJ in July 2025. And most of the people who are giving us the knowledge are coming from Europe or from Australia or from New Zealand, from USA, from UK. So this is something that should be addressed. And I think, again, environmental issues are tendency nowadays. So for the youth, for the generation that you are, please dig on that. You have 2 tendencies in international law that are really, we need people to dig more on a cybersecurity issue, environment. And I think also our arbitration issue, we have not a lot of people that are specialized in that. Again, that's why the Kilimanjaro Academy gives opportunity to people like you to have this knowledge, this plus value. You put it in your CV and you build on it. Myself, I've never had any course on international law, the African Union, 0, nothing, in all my courses. When I became elected member of AUCL, immediately I thought about a master's degree on African Union law in my country, in my university. So you can see that some person, just one person, can make the difference. There is a lady called Virginia Morris. Some of you maybe know her. She's American and she likes a lot Africa. And she's doing a lot of lectures online, sometimes with more than 1,000 persons during the lectures, to do dissemination of international law of African Union. One person with nothing, 0 budget. She has nothing, no secretariat, nothing. She only has connection. Abdel Qawi Youssef, myself, and other people who will give our knowledge just for free because we believe in this idea of really Kilimanjaro Academy of African Union law. You find nowhere, not in African countries, nor outside. I've done a lot of research. Even in France, they have something on integration, but it's much more anthropological, sociological. There is no law in it. So please think about it, and you are our ambassadors. Once you are back, make the difference. You can do clubs, you can do a lot of things with association, media. I can tell you that when I finish my master's degree, I have no possibility to continue with it. I've done podcasts in dialect, Tunisian dialect, 22 podcasts for people, anyone. He's just whatever, taximan or doing anything, just he put the podcast on YouTube and he will understand what is Pan-Africanism, what is the Pan-African Parliament, what is AFCFTA, what is a Human Rights Court in Banjul, in Arusha, and what is all these issues. We do not have the knowledge. I can tell you, this is my, at least it is my observation. I travel a lot, and the first thing I ask the taxi man, do you know what is Agenda 2063? Just for fun, no one knows. No one knows what is Agenda 2063. Do you know what is Banjul Commission? Do you know what is the African Court? You as a human being, if you have no rights in your country, there is some things called African Court on Human and People's Rights. Are you able to know where is it? Something like that. It is just, this is ordinary people who ignore completely our legal instruments and mechanisms. So what about the lawyers? What about the advocates, the judges? I do a lot of training for judges and for lawyers, and I'm speaking about African Court. No one knows. Before I began the course, I just give a QCM, and people do not even not know where is Banjul, where is Arusha, where is it even in the map. This is just to give you our controversies, our challenges. We should be courageous enough to address them, to open our eyes, and to see solutions. And we are here part of this dissemination. This is the most important, and you can build on it. Be innovative. Do not say we have we don't have budget, we don't have resources. I'm speaking about myself. I gave you an experience of someone who dreamt about something different, and I did it. A master's degree in African Union law for 8 years that gives hundreds, thousands of people who begin to do research, to do PhD, to do articles. Before that, you cannot find a single word on African Union law. Even my colleagues who have their courses on international law or on human rights, I'm speaking to them. Why do you have no section on African Court? They say, we don't know about it. So there is no doctrine, there is nothing in French, at least French literature, that are speaking about the jurisprudence. I said, why you do not have the opportunity to do some research on the website? The website of the court is in all languages. The jurisprudence of the court is in 5 languages. So everything is available. Do the work, have something. People are just copy pasta, and they do not update. There are people who have courses for 20 years. It's the same. They do not update it. For me, I come to my course, I just need to open CNN, BBC, and to see today what is the new thing. International law is evolving very quickly, and you cannot address people who have their phones, who are updated with things of 80s, 90s. This is my observation also. Our professors, with due respect, I respect a lot of them, all of them, because we are the product of these people. However, sometimes you find that they are not updated. They do not update their information. I'm giving you just a simple example of how advisory opinion on climate change was not addressed in a single phrase or sentence of all the heads of states and government who came to Addis Ababa in November 2025 addressing climate change. Can you imagine that? So I was just shocked. No one, absolutely no one, including the RB, that is the Department of Agriculture and Environment within the Commission of Agriculture in the African Union. So this is a gap. It's a huge gap in our knowledge, in our understanding. And I think, again, when I go there with the slides, you will find how important you can do and you can build on it. I'm speaking about reparation. This is a very important issue. I'm speaking about billions. And now reparation for Africans, it is only reparation on the issue of transcended of the slavery, this era. We have the theme of the year, so we have a resolution, and slavery and colonialism now are a crime against humanity. This is the resolution from United Nations. So people in Africa, they're aware about it. Ghana is leading that. However, the issues of environment, no one speaks about it. And that's why we are trying with workshops to go to people, especially the ones in the ministries of environment, and professors who are dealing with international law and environmental law. So I think, again, I really thank the people who thought about introducing a course on environmental law in Academy of Kilimanjaro. I know that I have really not a lot of time, but I need to go very quickly, and I need also to listen to you and to your comments. All I'm doing now is to go very quickly on the different other legal instruments to reach the challenges, globally speaking. And someone needs to comment?
Yes.
Okay, I will give you the possibility to comment. I know that I spoke for 1 hour now. Please.
Thank you, Professor. I have been following your presentation, and I have really appreciated on how you have gone through the 4 parameters in terms of challenges, specifically on the matters of clarity of law, where the laws seem to have been ambiguous, but also enforcement mechanism, but also institutional support in terms of effective remedies and accessibilities of these laws. It is of my opinion that the implementation gap is real, but it should not be automatically be treated as a failure of compliance. We have been hearing throughout the discussions that we already know our enemy towards these laws. First enemy is implementation gap. And secondly is the enforcement of these decisions. I was thinking on how can we move from that barriers towards implementations of these laws. We already know that the problem is implementation. Why do these people, when they make these laws, not testing the intended effects in practice, that we are making these laws, we need this to be intended or to be practiced in this way, and we have to reach that goal rather than just making a law and just leaving it while we still know the problems is in implementations. But also when it comes to the decision, enforcement of the decisions, that the court's decisions are not enforced, are not adhered, I think there's a problem in terms of rule of law, and which of myself I found it's a very big problem in most of African countries. The only decisions or enforcement that are complied mostly are from the executive. And once it comes to the judiciary, it comes like an opinion, just an advice, whether they take it or not. So why, let us think, all of us in this room, we already know the challenges. What are the way forward? Because we can discuss a number of conventions, a number of treaties, and still hearing the same challenges. How do we, let's make our minds think on how to move, because I think it's the aim of also this academy, to think, to create a room for us to think on how are we going to move to these challenges. You're mentioning good laws, Bamako Convention, the 1960 conventions, but I'm very eager, why don't we reach while we already know our enemy? Maybe you help us.
Political will, and we are here again to... Yeah, thank you so much. So again, we are speaking the same language, we understand each other. I'm a professor, I'm a poor person, I have nothing to do with executive. All what can I do in my domain is dissemination, is just gathering people like you and encouraging and just putting the barrier very high and be innovative and tell people, please never give up. We have to be together and we have to think out of the box, and this is the responsibility of everyone. You are completely right. We come, we speak the same language, we see the same challenges, nothing is moving. Maybe there is something moving, because the first day I listened to a lot of you, and there is some things done in some countries. However, as you said, the whole picture is still not good. It's very bad even. And just we spoke about our touristic roads. This is something that is not hidden. Everyone has the main roads, the main city in his country, and he can see that till now we cannot compare our countries and our continent, even if we are very rich, to the standards, the universal international standards. We are still behind, and this is not fair. And we have still problems of corruption again, we have still problems of pollution, we have still problem of how to implement these laws, we have still reticence from the member states to ratify these conventions. So all these issues, we know all of them. It is not between my hands to find solutions. I think, again, we addressed that in a global manner. Dissemination first and action after. It should be, as I said, a whole circle. The legislative, the executive, the judicial, but also civil society, mass media, education. All of them come together. Environmental issues are really very impactful. anyone, even if he's not a lawyer, even a child, 6 years, he understands environmental issue. And sometimes arts, I'm telling, music or some theater or piece of, or comment or 1 second on TikTok can do the difference. So please, let's do it together. It is not up to me to find the solution. I cannot help. All I can do is to give dissemination, is to put the light on our instruments. But you are the policy makers. You are the professors. Once you go back to your home, you can make the difference. You can speak to your ministers and be their advisor. You can be the experts. You can be the lawyers. You can be advocating nationally, regionally, and internationally. There is a lot of means to be done. It is not up to one person, to one group, to one country. And again, put yourself in the big picture. We are struggling, multinational that has interests, that are much more important than human beings. So this is also something that we need to address. But at least we are frank, and we speak with the heart, and we need that there should be some change, and we need to believe that there will be change. So, and things after will move in the right side if we just have the political will. I see someone who needs to comment. Who else needs to comment? Here? Here and here. Very quickly and be brief because I have still 20 minutes to finish.
Merci pour la parole. Et nous venons de suivre avec attentif votre exposition. Et tout ce que vous dites, c'est fondé. Nous, on ne refuse pas. Mais j'ai noté que vous avez dit la question de l'environnement, c'est une question des droits de l'homme. Les droits de l'homme, c'est une question de mentalité. Oui, c'est vrai. C'est une question de mentalité. Mais jusque-là, dans le secteur de l'environnement, il y a encore un défi. Et c'est un défi qui touche à tous les niveaux, au niveau politique, l'organe politique, l'organe juridique, y compris aussi l'organe d'exécution. Mais ce que moi je peux vous proposer, bien sûr, tu n'as pas ce mandat-là d'initier une loi, mais est-ce qu'il n'y a pas moyen au niveau de recommander à l'Union africaine d'initier un cadre très approfondi, un cadre de réflexion pour initier des lois, les lois qui peuvent commencer à accompagner l'organe politique de manière stricte. Oui, chaque État est souverain. Et il est responsable de soi-même, mais jusque-là, ça ne suffit pas. Il faut qu'au niveau de l'Union africaine, qu'il y ait un cadre de suivi, un cadre juridique et aussi un cadre de suivi de mise en œuvre dans chaque État. Est-ce que vraiment l'aspect de l'environnement est respecté? Est-ce que les lois qui sont adoptées dans chaque État est respectées? Et est-ce que on applique ces lois-là dans le pays? Puisqu'il y a des pays, les lois existent, mais il y a toujours de légèreté au niveau de l'organe politique. Même si au niveau de l'organe juridique, il y a cette volonté-là d'appliquer la loi, mais quand on arrive au niveau de la politique, là on est frustré. Donc vous voyez que le secteur de l'environnement, il y a encore un défi. Maintenant, je peux aussi recommander à notre cadre ici, l'Institut international des droits de l'homme, c'est mieux aussi de commencer à collaborer avec, avec la Cour de l'Union africaine pour commencer à accompagner les, oui, y compris aussi les étudiants, bien sûr, au niveau des universités, commencer à sensibiliser les étudiants dans chaque pays, organiser des forums d'échange, les forums de discussion dans chaque pays de manière rotative. Peut-être ça peut aussi aider à la communauté d'être toujours informée que nous devons respecter la loi et nous devons aussi respecter le, 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 les secteurs de l'environnement. Voilà, merci beaucoup.
Je vous ai bien écouté, je vais rapidement faire une petite réflexion par rapport à ce que vous dites, qui n'est pas juste par rapport au cadre de l'environnement, mais par rapport au droit international en général. Je le dis, je le redis, en matière de droit international, les États membres n'ont pas le monopole de légiférer, n'ont pas le monopole de la force, n'ont pas le monopole de la justice. Par conséquent, au niveau de l'Union africaine n'est qu'un bras à exécuter ce que les États membres demandent. On ne prend pas d'initiative. Nous-mêmes, le bureau du conseiller juridique, nous sommes le secrétariat de ce qu'on appelle le STC Just and Legal Affairs, c'est-à-dire c'est la structure qui vient regarder les drafts de toutes les conventions et les futures conventions. Ce n'est pas le bureau du conseiller juridique qui initie, ce n'est pas le Parlement qui initie, on n'est pas comme le Parlement européen où là, il initie des lois, il initie des conventions et de projets de conventions. On n'est pas encore là. Notre Parlement panafricain est toujours un organe consultatif. Il ne prend pas l'initiative de légiférer. Qui le fait? C'est la conférence des chefs d'État et de gouvernement. Par conséquent, c'est les États membres. Bien, et une bonne question ici par rapport au corpus juridique. Je ne suis qu'à 20%, donc il y en a encore d'autres instruments juridiques. Et je me demande si ce corpus est suffisant ou il en faut encore. Et on va vous dire que, naturellement, en droit international, bien sûr, les choses évoluent, mais on a déjà ce qu'il faut. Les questions de implementation et de mise en œuvre, elles sont déjà dans les textes. La question de la Cour et de la commission de Banjul font aussi le travail. Néanmoins, encore une fois, on n'a pas d'organe supranational. On est toujours dans des entités de, pour moi, d'ailleurs je vous dis ma conclusion sur ce que est l'Union africaine, pour moi, à ce moment, en ce moment, nous sommes toujours une organisation de coopération. On n'est pas encore une organisation d'intégration comme l'Union européenne est. Au niveau de l'Union européenne, quand il parle de légifération au niveau de la communauté européenne, on parle de directives. Et ces directives, parfois, elles ont même une place supra-constitutionnelle. Je me souviens, la France avait même changé sa constitution par rapport à des directives européennes. Est-ce qu'on en est là? Nullement. Je peux vous dire, d'après mon expérience, il y a une quinzaine d'années, que les États membres grignotent la virgule et la phrase et le mot. Grignotent carrément. Je suis la secrétaire, le bureau du conseil juridique, il assure le secrétariat de ce STC, c'est-à-dire la structure qui fait tout ce qui est drafting des futures conventions. Déjà, on fait 3 semaines de travail, on termine parfois minuit, 2 heures du matin chaque jour, parce que dans la salle, il y a des États membres qui sont réticents sur des paragraphes en matière de droits de l'homme en général. Tout ce qui est technique, ça passe. Mais là où on reste très longtemps dans les délibérations, c'est au niveau des droits de l'homme. Et ces États membres, ils grignotent sur les phrases, sur les mots, alors qu'on n'est même pas au niveau de la ratification ni de la signature. Et on leur dit, dans le droit international, il y a cette technique extraordinaire qui s'appelle réserve. Pourquoi vous êtes en train de nous bloquer? C'est un document qui a mûri, qui a pris très longtemps, 4-5 années. Je vous donne l'exemple, par exemple, la convention sur les questions de statelessness, c'est-à-dire les gens qui n'ont pas de nationalité, la question de ending violence against women and girls, mettre fin à la violence contre les femmes et les filles. Ça, ce sont des questions récentes. J'en ai vu des choses, 2025-2024. Ça nous a pris un temps fou pour faire passer des conventions. On est même au stade de brainstorming. Et ces États membres, ils peuvent, s'ils le veulent, faire des réserves. Et on passe. Alors tout ce qui est partie implementation, mise en œuvre, contrôle, ils érasent ça carrément d'un balai de main. Ils ne veulent surtout pas voir des mécanismes qui surpassent leur souveraineté. Et la plupart de ces États, ils mettent en avant le raisonnement, l'argument souveraineté. Souveraineté de notre État membre. Par conséquent, encore une fois, ce que vous dites est tout à fait vrai, mais c'est entre les mains des États membres de faire passer ou pas. Et je me souviens très bien dans des sommets très chauds de l'Union africaine où des États membres ne voulaient même pas que l'on mette le nom de leur pays dans les rapports. On vous dit d'accord, mettez la situation X, Y, mais ne mettez pas le nom du pays. Pensez-vous à ça? Vous avez donc des commissaires de la commission de Banjul qui font des rapports sur les droits de l'homme, mais des États membres qui disent non, 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 ces rapports ne sont pas véritables. Et donc les rapports, enfin vous savez mieux que moi, les rapports, on a le Conseil des droits de l'homme aux Nations Unies, et que les rapports gouvernementaux ne sont pas suffisants. Ce n'est pas la seule source d'information en matière des droits de l'homme. On a besoin de la société civile, des médias. Alors pratiquement, on diabolise tout le monde, c'est tous contre tous, etc., etc. Arrivé en matière d'environnement, je vais terminer ma partie. Vous allez voir que implementation, mise en œuvre, monitoring, les rapports périodiques, tout est là. Sauf qu'au niveau de la mise en œuvre, un État, il va vous dire, ça ne vous concerne pas. Ou bien il ne fait pas de ratification, il ne signe pas, ou bien il signe ce qu'on appelle une signature façade, vitrine. Vous savez mieux que moi que l'argent qui vient du FMI, qui vient de ces grandes institutions financières internationales, viennent contre des rapports droits de l'homme. Donc pour moi, je vais dire, je suis un bon élève en matière de droits de l'homme. J'ai ratifié cette année X traités, j'ai fait X rapports en matière de droits de l'homme. J'enseigne les droits de l'homme au niveau de l'enseignement supérieur, le baccalauréat, dans mes lycées, je fais XY. Juste façade, vitrine, c'est juste une manière de vendre, n'est-ce pas, que je suis un bon élève en matière d'état de droit pour avoir des millions en tant qu'aide financière. Mais la vérité, vous le savez mieux que moi, dans nos pays, on est loin. Ils sont rares les États africains qui ont vraiment une... je suppose que tous les enseignants qui sont là sont en train de dire la même chose, y compris celui qui avait initié cet institut, le professeur, l'éminent juge Abdelkawi Youssef, qui parle de façon franche et qui ne mâche pas ses mots. Et avec lui, on fait des disséminations au gouvernement. Moi et lui, je fais carrément des actions de dissémination, de ratification des instruments juridiques. Et on va aller voir des chefs d'État, des ministres, des parlementaires. On ne mâche pas nos mots, on parle sincèrement. Et on trouve de l'autre côté des gens froids, n'est-ce pas? Comme a dit quelqu'un, les États, ce monstre froid. Donc ils sont là, juste, ils nous écoutent, ils prennent note, d'accord, c'est en cours. On va en parler, on va discuter, on va négocier, et puis ça prendra 10 ans, 20 ans, je ne sais plus. Donc malheureusement, nous avons besoin, encore une fois, de personnes comme vous qui font la différence dans leur pays, qui lorsqu'ils seront de retour, ils pourront créer ce qu'on appelle une mentalité commune, un sens de vouloir vivre en commun qu'on n'a pas carrément. Donc je peux vous dire, moi, dans mon pays, quand je demande quel est le nom du président du Sénégal, mes étudiants, je fais toujours ces tests. Est-ce que vous savez quelle est la capitale, par exemple, de Sierra Leone? Personne ne répond. Est-ce que vous connaissez c'est quoi la charte de Banjul? Personne ne répond. Donc, alors que dans les curricula, on connaît pertinemment la géographie du Japon, du Brésil, des États-Unis, de la France, et on ne connaît rien de notre Afrique. Et donc, est-ce que c'est délibéré? Point d'interrogation. Il n'y a pas assez de... nos traditions africaines, l'art africain, le cinéma africain, les champions africains, on ne connaît rien de tout ça. Je parlais de valeurs, je parlais disons, d'éthique, je parlais de sommité africaine, le panafricanisme. Est-ce qu'il est connu dans nos pays? Je ne le pense pas. En tout cas, dans ma région, l'Afrique du Nord, on tourne carrément le dos à l'Afrique. Nos valeurs sont autres et ce n'est pas bon. Et je pense pour arriver là, justement, c'est ça un peu pour nous unir. Donc, en fait, tout le but derrière l'académie, derrière l'institut, c'est de ramener une jeunesse africaine, mais aussi d'ailleurs, n'est-ce pas, pour nous inspirer de par leurs expériences, mais que cette communauté avait vécu ensemble. Et ils se sont dit, on peut faire quelque chose ensemble. Et ça peut se faire. En tout cas, dans mon pays, encore une fois, on fait très peu, sinon rarement, avec les pays africains, alors que nous signons tellement de partenariats avec des universités italiennes, françaises, espagnoles, et nos voisins immédiats, la Libye, l'Égypte, l'Algérie, rien ne se passe entre nous, ce qui n'est pas normal. L'intelligentsia et le savoir-faire africain, il est là, il est partout. Regardez qui sont au niveau de la CIJ, au niveau du tribunal des droits de la mer, au niveau des grandes instances internationales qui ont les affaires africaines, qui plaident pour l'Afrique. Je ne vais pas nommer des noms, mais vous le savez. Il n'y a personne de l'Afrique et ce n'est pas normal. Il y a pratiquement des experts de renommée en Afrique. Mais nos États membres, malheureusement, ils prennent un Américain, un Français, un je ne sais qui, alors que nous ne manquons pas d'expertise, nous ne manquons pas de savoir-faire. Et parfois, ces experts ne connaissent pas nos affinités, nos spécificités africaines. Ils ne peuvent même pas connaître la manière, la coutume, la tradition, le savoir-faire africain, et donc ils peuvent même induire en erreur le juge avec des hors-sujets. Donc je pense encore une fois, c'est vraiment là où on est en train de former une nouvelle génération qui pourra faire la différence au niveau des instances internationales. Et c'est comme ça que vous tirez profit justement de ce système où il y a un grand déséquilibre en faveur de pays riches, développés, malheureusement, qui font la pluie et le beau temps, il faut le dire, et on le dit franchement, avec des exceptions. Donc tout le but, encore une fois, de cette académie, de cet institut, de ce que nous faisons, c'est de ramener des Africains ensemble pour avoir le savoir vivre ensemble, pour avoir une intégration autrement que politique. Nous, on veut to revert ce qui est politique. Ces obstacles politiques, on peut le faire autrement, avec une jeunesse qui a des rêves, qui a une autre tendance du panafricanisme, un. Et de deux, tout ce que vous dites là, la résistance justement à ces obstacles qui font que tous nos textes restent une coquille vide qui n'a pas de sens. C'est juste paroles et paroles et paroles, et comme dit Dalida, n'est-ce pas? C'est juste des choses qui sont écrites, vous l'avez dit tout à l'heure, sans que ce soit quelque chose dans lequel nous croyons. Et pour inverser la donne, on a besoin de gens comme vous, qui, une fois vous serez chez vous, vous ferez la différence dans votre domaine. Donc c'est un peu ça ce que je voulais dire, mais je suis tout à fait d'accord avec l'analyse, la manière avec laquelle vous voyez les choses. C'est le constat, malheureusement, et c'est un constat amer et qui fait mal. Est-ce qu'on doit pour autant être réticent au changement, aux recommandations, à la révolution, à l'évolution? Non, nullement. On est là justement pour faire pousser les choses. Et rien, nothing is granted. Personne ne vous donne sur un plateau d'or, surtout les droits de l'homme et les questions de droits de l'homme, les questions de droits de l'environnement. Il faut les arracher. Donc ça aussi, c'est notre travail. Dernière personne qui veut, je pense, c'est là. It was you who needed to take the floor, please. Here, you needed to take the floor. Yeah, please, quickly.
Thanks, Prof, for such a brilliant presentation. Actually, you are hitting the nail on the head. Let me start by quoting some of the famous politicians, especially Mwalimu Nyerere. He used to say that it can be done, play your part. And then President Barack Hussein Obama used to say that we are inherited this word for our future generation. What I'm trying to say, we should not give up, since even this Kilimanjaro Academy 2026, most young generation who are supposed to inspire others. What we're supposed to do is to take lessons and the skills we are getting out of this Kilimanjaro Academy and go to our respective area and try to enforce them. Since these environmental problems are throughout the world, and every government, they ratify various protocols for the environment, and they normally meet. For this year, for instance, we'll be having a COP in Turkey for climate change. People are not giving up. So it's a matter of fighting death and life to try to address these environmental issues. Taking an example of USA. In USA, the environmental challenges or environmental campaigns started all the way when Rachel Carson wrote a book of Silent Spring. Maybe everybody can go there and check about the book. And then the US government in the early 70s started to enact some of the acts, such as Clean Air Act, Clean Water Act, but still, even in the US, pollution is there, environmental problems are there. We have colleagues from the US, from Michigan University. It's clearly most of the diseases which are killing Americans is cancer and asthma, and they are all associated with environmental pollution, starting from water contamination by lead, being water source being contaminated by lead, or either having a polluted air, because, but they're still campaigning. And these environmental challenges, sometimes they are really difficult to tackle them, since we have also economic powers in it. You find that these companies which are trying to produce goods, they sometimes try to maximize the profits by using cheap source of either inputs and other raw materials or means of production or technology. So by doing so, it has externalities in terms of environment. But this is not it should not be a hurdle for us to fight for this war against environmental conservation. So what can I say? Everybody, including me, from this Kilimanjaro Summer Academy, should take the skills from here and go there to enforce. It makes no sense to come here to spend like 14 days getting all the skills and then just ending up in books and putting them in shelves. So it's time for me and you and everybody in this room to get out of this small, tiny room of Kilimanjaro Summer Academy 2026 and go outside there in the field. Try to play your part. Mwalimu Nyerere used to say, it can be done, please play your part. Thank you.
I'm very happy to hear from you. This is very interesting. Please write your book. Okay, now I have the challenge to finish all in 5 minutes. I will try. As I'm saying, we have the Charter on the Rights and Welfare of the Child. There are some environmental provision. I will go directly to the ones on how to incorporate environmental education. It is mainly the Article 11. In the Article 11, you remember at the first glance, we spoke about how to recognize the importance of environmental education. And this article states that the education of the child shall be directed to the development of respect for the environment and natural resources, and this provision highlights the need for children to not only be aware of environmental issues, but to also be equipped with the knowledge and skills necessary to protect their environment. We also have the Article 40, Implementation, Impact and Challenges. We have an Article 41 on opportunities for advocacy. And as a conclusion for this one, the protection and the comprehensive protection, this African Charter on the Rights of Welfare of Child stands out a robust framework that addresses the unique challenge faced by the African children. It ensures that issues specific to the region, including environmental concerns, are not overlooked, and it symbolizes Africa's commitment to nurturing a generation that is aware of its rights, equipped to face future challenges, and dedicated to protecting the environment. Now we have another one, the African Charter on Human and People's Rights, on the protocol on Maputo Protocol on the women's rights. I don't have a lot of time, but again, all my notes are already sent on the group. I think I sent to Matthias. And I think just I will go very quickly to other one. This is the 1970, this one, 67, Phytosanitary Convention for Africa on environmental and agricultural implication. It has historical context. I have no time to do, but all I need to say is, I will go directly to the conclusion for this one. So this is a significant opportunity to align this convention with the International Plant Protection Convention. It could provide a more detailed framework for phytosanitary measures, including specific guidelines on certification and pest management. It has a context that's technical. I will just jump it. There is also the convention here, 1981, African Center for Fertilizer Development. We are supposed to have this center, but I think it is still not fully operationalized. There is a lot of gaps and concerns. Just I will go to the other slides. We have here the African Maritime Charter, Transport Charter. Here we discuss the revised African Maritime Transport Charter that is adopted in Kampala 2010. It updates and expands the original 1993 charter, and it is reflecting the growing importance of maritime transport in Africa's economic development and the need for environmental protection in this sector. Yes, as like the other ones, there is plus value, but also there should be some gaps, especially about the implementation enforcement mechanism. I come here to a very important another one. It's called the Balindaba Treaty. And this is the African Nuclear Weapon Free Zone Treaty that is known as Balindaba Treaty. And this treaty represents a significant milestone in Africa's commitment to peace, security, and environmental protection. And this treaty do not only prohibits the proliferation of nuclear weapons, but also addresses the environmental and health impacts of radioactive materials. And here you can find some details. We have AFCON. Maybe you do not know that we have already African Commission on Nuclear Energy, and that its headquarters is in Pretoria in South Africa, and they are doing a very good job. Maybe if you are curious enough, please go to their website. It's very well done. AFCON has some responsibilities like including collating reports, facilitating information exchange, convening conferences to address issues related to the treaty's implementation. It also reviews peaceful nuclear activities to ensure they align with international safeguards set by the International Atomic Energy Agency. Now I will go very quickly to another issue. It's about the part on the court, the jurisprudence. These are the legal challenges, but I'll go very quickly on that. We spoke a lot about the challenges and how to address them. There is some involvements of African position, like Kigali Amendment of Montreal Protocol, and the aim is that of this impact of this amendment is profound, with the potential to prevent up to 0.5 degree of global warming by the end of this century. However, for African countries, the economic implications are significant, particularly the costs associated with the new technologies and the impact of industries related to the HFC, that means the hydrofluorocarbons. So we have a lot of challenges, but also opportunities. I need here to highlight, it's very important for me, to speak a little bit about the role of AU in climate governance. This is very important. AU plays a central role in coordinating the continent's response to climate change. It represents African interests in global negotiations, supports member states in implementing climate policies, and promotes regional cooperation in climate-related issues. We have the AU Climate Change and Resilient Development Strategy and Action Plan 2232 that outlines a vision for a climate-resilient Africa, setting strategic objectives for enhancing climate governance, promoting green growth, and building resilience across the continent. We have key AU initiatives that are including the African Climate Policy Center. We have also a lot of other things. Maybe you can, as I said, in Ethiopia, if you are interested to come for COP32 the next year, I'm sure that we will put in advance all what we are doing at the African continent. The part that is coming now is about advocacy and how we can do the difference as Africans at the international arena, and how as Global South, and especially as Africans, we have a voice to be held at the international law level. And maybe you remember ITLOS and the issue of the law of the sea and the participation of AU in ITLOS. This is the team. Before I came, this was at the time of Namira Negm, who was the former legal counsel. We have an AU written statement on ITLOS, and the ITLOS, or the Tribunal of the Seas, is responsible for settling disputes that raise under the United Nations Convention of the Law of the Sea, Montego Bay Convention. And given the complexity of the maritime boundaries and resources shared by African nations, ITLOS has become a critical arena for resolving such disputes. So African Union at that time gave and submitted a detailed written statement to ITLOS responding to a request from the Commission of Small Island States on Climate Change and International Law. And this request seeks clarity on state obligations under the United Nations Convention on the Law of the Sea, particularly regarding the impact of climate change on marine environment. And I think it was a success. ITLOS, and you can see some details here. I have no time, but there is a lot of recommendation, and we built on the case when we go to the ICJ. These are some pictures of ICJ. I put here my Office of the Legal Counsel at what are the main mandates of the African Union Legal Council. And here is the December 2024 issue with the climate change advisory opinion. And we have a statement, I sent you on the group our written statement. And this is the team, this is our, just extract the day when I went there. I was the last one after Latvia, Liechtenstein, Malawi, Maldives. African Union was the last one. And this is the team, and you can see Mbenge, this is the one. Makan Mbenge is one of the most important pioneer law Africans in the domain of environmental law. And as I said, Abdel Qawi Yusuf was there, and he's also one of the best judges who've done a lot of work in this advisory opinion. So here I'm trying to put a question. How can international legal mechanisms like the ICJ and ITLOS be leveraged to hold states accountable for the global climate crisis? And what are the potential implications for African countries in using these platforms to advocate for climate justice and the protection of marine environments? Number one, are we as Africans aware about this jurisprudence, about this advisory opinion? So be curious enough to go to the ICJ website to see what is this advisory opinion about. I think this is a landmark, unanimous advisory opinion on the obligations of state in respect of climate change. You'll have all details in my remarks where I put some issues on fossil fuels and subsides. I put some issues on environmental impact assessments. I put some issues on, and this is very important, state responsibility and reparations. And these are general rules of state responsibility that apply to climate change, meaning countries that breach obligations may face accountability and requirements to provide reparations or compensation. It is true that this is a non-binding advisory opinion. However, while advisory opinions are technically non-binding, they carry immense legal weight influencing future international climate negotiations, policy updates, and domestic climate litigation worldwide. And this is maybe one of the rare times when we have unanimous consensus. All the 15 judges, without any exception, concurred on the core obligation closing. Previously argued that the major historic and current greenhouse gas emitters, and I think, as I'm saying, this was built on the Inter-American Court Human Rights Historic Advisory Opinion of 3rd of July 2025. I put you some core legal findings in my notes, and they also highlighted the importance of the pending advisory opinion on obligations of the states with respect of the climate change crisis here within the African Court of Human and People's Rights. And because of PALU, I think you visited the Pan-African Lawyers Union. Together with the African civil society networks, they are requesting this advisory opinion, and we are waiting for the 4th advisory opinion on issue of environment after ITLOS, after the Inter-American Court, and after the ICJ. So this is about the courts. Now, call for action, I think, about global cooperation. This climate crisis is a global challenge that requires a global response. No country, no matter how powerful, can tackle this alone. And we must forge a path of cooperation guided by the principles of justice and equity. And our participation in the ICJ advisory proceedings, including the timely submission of our written statement and upcoming reply, so there is already a reply, is a powerful statement of our commitment to these principles. And I think it is important that we recognize the gravity of the moment, and the future of humanity, particularly of Africa, hangs in the balance but with decisive collective action informed by the rule of law and driven by a sense of shared responsibility, we can really chart a course towards a more sustainable and equitable future. Now I needed to come with some other challenges. And among these challenges in implementing environmental and climate laws in Africa, we spoke a lot about the political will. This is number one. However, despite contributing the least to global greenhouse gas emissions, our African countries are facing significant challenges in adapting to and mitigating the effect of climate change. Implementing environmental and climate law in Africa is really having a lot of challenges. We have financial constraints that are a significant barrier, as many African countries struggle to access international climate finance and meet the criteria for funding. We have also institutional weaknesses such as bureaucracy and corruption. We have limited interagency coordination, and we have also the shortage of technical expertise needed to adapt and scale up advanced environmental technologies and practices. I think we don't have a lot of time to go further. The public awareness is important. The impact is that this lack of awareness results in poor public support and engagement with environmental policies and initiatives. And I'm sure that if we have to access climate data and technology, things can be better. And as solutions, we can speak about capacity building. We can speak about here solutions. Capacity building, we can speak about international collaboration, innovative solutions like encouraging the adoption of low-cost, accessible technologies tailored to local context, policy recommendation as integrated approach, enhancing public participation, especially governments and NGOs should focus on enhancing public awareness and participation through education, through community-driven initiatives and transparent communication about climate policies and their benefits. We have also to improve access to data and technology. We have a lot of case studies that are successful, like the Great Green Wall Initiative and its achievement. In South Africa also we have renewable energy independent power producer procurement program launched in 2011. So these are case studies that can be interesting and can be inspiring. We, as conclusion, can see that we are still far, as I'm saying, we need reforms, yes, but how we can improve our legal framework where there is no political will. I think we are already after the time, with 10 minutes. All I want now, tomorrow it will be ecocide. I'm saying that for tomorrow we'll go through the ecocide issue as the fifth crime, international crime within the ICC. But before that, what I need is that you divide yourself in groups. I gave you in the document 2 a simulation, a case. I will go through it very quickly. It's very short, just to see how we can divide ourselves, please. So organizer, give me just 2 minutes to go to the exercise. In this exercise, let's jump to the last part. You have 1, 2, 3, go directly to the last part. All I want you to do is, I'm finishing, just 2 minutes. Huh? Question. Just I need to say what we have to do, and after I will give you questions. In the case, if you can see the last pages, there is a scenario, and this is the River Verde dilemma. The scenario is the following. River Verde is a vital water source for several communities in the fictional African country of Zambia. We'll call it Zambia. The river sustains agriculture, provides drinking water, and supports local biodiversity. However, the government of Zambia has recently approved a large-scale industrial development project to build a hydroelectric dam on the River Verde, arguing that it will provide much-needed electricity for economic growth. Local communities and environmental groups are concerned about the potential negative impacts, including displacement of people, loss of biodiversity, and long-term environmental degradation. The project has sparked a legal battle that was reached at the Supreme Court of Zambia, with various stakeholders presenting their case. What I need you to do is to divide yourself in groups. There is a group of the judge who will decide if the dam project should proceed to be modified or to be halted. I need another group of government lawyers who will argue the economic benefits and planned mitigation of environmental damage. This is development, sustainable development. I need another group of community lawyers who will defend the rights of displaced communities and the environmental impact. Another group of environmental lawyers that advocate for biodiversity preservation and strict enforcement of environmental law. And I need a group of civil society that will plan a campaign to influence public opinion and policy advocating for environmental justice and community rights. So what I need is that you divide yourself in groups and that there will be volunteers who will represent the group of the judge to deliberate on the arguments and to deliver a ruling balancing development needs and environmental protection. I need one to represent the lawyers and to prepare and present very short, it's about just 15 minutes, everyone will have 5 minutes, prepare and present compelling arguments for your client, focusing on legal, social and environmental implication. And I need a representative of the civil society to develop an innovative public campaign using social media, media outreach and public demonstrations to sway public opinion and pressure policy makers. So this is a little bit the question. I put the key questions. Number one, how can Africa achieve development while protecting the environment? Question number two, what role does the judiciary play in balancing economic growth and environmental justice? Number three, how can civil society effectively advocate for environmental protection in development projects? Is there any volunteers here in the room to play this simulation role tomorrow? Is there any people interested? Just, you can have, while you are having your lunch, groups and think about it. The judge will be represented by one judge who will tell us what is the judgment. And before that, we will put here just like as if we are in a tribunal. We are in a tribunal, by the way. We are in a court. There will be the one who will defend the government, Zandia, and there is the ones who will defend the civil society and the environmental issue. And you will put in advance all the instruments that Zandia had ratified. We will, as if we will put a scenario that Zandia already ratified all the conventions that I talk about, okay? So please, is there any people in the room? I need 2 people also to do some, qui font l'animation as a CNN or reporters, something like that. 2 people, one a female and a male to begin, as if we are on live and you are just putting, this is a landmark decision in Zambia, etc., and we will do this exercise just for 20 minutes maximum. So who will be the media? CNN reporter, Al Jazeera reporter. I have here one volunteer, thank you so much. Who will be the judges? The judges, groups, who will put the decision. Thank you for being part of the judge. So please see each other so that you can go to the groups. Who will be the lawyer of the government of Zambia? Who will say social development? These are Zambia lawyers who will defend environment and civil society issue. Thank you so much. So please, these are the people who are leading the groups, if you can be with them, so that you give some, some ideas, reasoning, and you put on written, and you come tomorrow. This is a simulation. And by the way, the 2024, when I've done the simulation, I asked the groups to send me the written issues, and I built my case in front of the ICJ on the way they put. And I was very inspired myself on how I built my case and how I addressed the International Court of Justice. If the one to be also inspired, go to the ICJ Vanuatu lady. She was wonderful. She spoke with the heart. She didn't see any of her papers. She saw the judge in their eyes. And the moment was magic. So see the people when they believe in the cause of environment and they speak about the people in the village having issues on environment, their island who will disappear in a few years. And she spoke with the heart. She has nothing, no written paper. And it was something that, the atmosphere was really something terrible because the judge understood. Same with Gaza. When I was Palestine case, the Palestine put images behind. I think all of you saw that on Al Jazeera. It was online. And these pictures, when we are speaking about war, the people who never had war, they don't understand how children are under this trust, etc., etc. So this is very impactful. So try to do as actors. You are actors today. It's theater. It's a piece of theater. So we'll do as if we are protecting the environment And the other camp, they are protecting the government and the businessmen and the billions that will come behind the dam and development, whatever. And the judges, they are the reason of the wisdom. They will give us something that will be built on the rule of law, on the legal instruments, that is balancing both the development but also the protection of environment. Put into your mind the principles that we addressed and we raised. And after we finish that, I finish with the part on ecocide. This is a very important issue, and I don't find it in the books of environmental law. It is something that is not very well developed. There is no doctrine. There is not a lot of people who think about it and believe on it, but I think it is interesting. We can just explore that. I'm sorry I took a lot of time after the break. I think someone needs to comment. I'm sad that there is someone who needs to ask a question. Please.
Thank you, Madam, for your good presentation and for encouraging us to disseminate knowledge. But these days, it's becoming a challenge even to disseminate knowledge, especially here in Tanzania. We have a lecturer at the University of Dodoma who was teaching in a class trying to disseminate knowledge, but he was later on arrested and charged with terrorism. So can African Union intervene in such incidences? Otherwise, it will be very difficult for us to disseminate knowledge. Thank you.
The law, and I have no mandate to address this issue, but I need to tell you that Tanzania withdrew the disposal on the Article 36 paragraph so that the people of civil society address the court directly. And I think one of the justification is the number of the cases against Tanzania, just because the court here is visible for Tanzanian. Now it's about the liberty of expression, liberty of academic liberties and freedoms. The only issue that you can do here is to go to Banjul Commission. When I think you have a professor giving you the course on human rights, and he's explaining to you that when we compare ourselves to Europe, in Europe they deleted the commission, they have only the court. For us, because African countries are not yet believing in this set of rules, we already conserved the Banjul Commission. So the commission can be the bridge. So the case can be brought to the Banjul Commission, who will bring it to the African court. Among that, again, because the sovereignty issue, so the only thing that you can do is making noise. It's about media, it's about civil society, but this is not a case of Tanzania only. I know too many cases of people who are in the jail just because they are doing their work, because they are just speaking about human rights issues and liberties and justice. This is not a unique case. However, again, this is just our realities, and it is really something very harmful and very sad. So I think, legally speaking, procedurally speaking, the only way you can do is to write. Go to the website, the Gambia Banjul Commission, and you can see how you handle that. There is a lot of procedures. There is a format that you can do, and they are le porte-parole. They will speak on your behalf. But for instance, you can do nothing unless, again, these are the issues that you can find in the protocol to the Charter of Banjul, when it said, après avoir épuisé tous les recours internes, la Cour africaine des droits de l'homme et des peuples est compétente après épuisement de tous les recours internes. Et tous les recours internes, ça peut prendre beaucoup de temps. So unfortunately, again, you have to go to the court after you finish with all internal procedures. However, there is one tricky expression saying in reasonable time. Reasonable time for us can be flexible, elastic, and can be for years. And other people can be in jail without any trial at all for years. And we know eminent professors, even in some countries, who are in this situation, and it is sad. So I think, again, we have to make noise. We have to see what can be the issues that can be done through the Banjul Commission. Connection, I can give you connection of commissioners who will deal with that. And as a long-term issue, I think it's important that we do capacity building on liberty of expression for judges, for media, for professors, whatever. I think it is still important that we resist. I know that this is very difficult. We've done in our country a revolution because of that. liberty of expression, fairness, equity, justice. This was the spring, whatever, it was 2011. It begins in my country. And it is all these slogans saying, game over. It's very powerful, game over. And after that, it was a storm in all the region. And you can see that the impact and the implication are depending from one country to another. It is true that in my country, 13 years after, we are still, you know, there is no really real democracy, there is no growth on the economically development, whatever. In other countries, Libya, it was a war for a long time. For other countries like Syria, like Lebanon, like Jordan, you can see it's depending. Morocco, it's a kingdom, so they've done reforms. So every country has its own culture, its own mindset, its own issues, and its own people who can resist or not, who have long time resistance or not, who can do the difference or not. And at the same time, I think, and this is something that I'm observing, people are discouraged, and that's why they are trying to flee either the illegal immigration, and we see people crossing our borders, going to Italy, to France, to Spain, or the brains, what is called brainstorm, brainwash, yeah, the intelligentsia, who have better future in Canada, in USA, they brain drain. They will leave the country forever, and they even do not have any ambition to come back. And again and again and again, this is the aim of what we are doing, making the difference through education, through dissemination, and through being as a groups. If we have people coming from African Union, please raise your voice. And I can indirectly be, I don't know, just giving the information to some colleagues who can be more influent than me. As a legal counsel, I have no mandate. I'm only technical, and I put you in the presentation what are the mandate of the Office of the Legal Counsel, but thank you for raising that. Yes, please. I think the organizer will kill me. I'm taking the time of the next professor, but I know that this is very interesting communication. Please.
Thank you so much, Prof, for your presentation. I just want to share what I have with regard to what my colleague has asked. I'm from Tanzania also. Yeah. With what has happened, with the case that she mentioned, I believe I've also disseminated information, and I mean, in a way that we understood. So also in the academic area, I believe the lecturers have to do so, just like the way you did. It means if you have done like if they do the way you have done, there will be no charges. But if you use words or if you use terms that are enticing or, yes, offensive to the government, there are consequences to that. I'm speaking from the prosecution point of view. So we have to be very conscious with whatever we are delivering to a great number of people. That is what I would want to advise any of us.
Okay, this is not my environmental law course, so please, any other questions on the issue of environment? Very quickly. Organizers, can you give us 5 minutes? Sorry. You are speaking too much. I will give the ones who didn't speak. Okay. Priority to the people who didn't speak ever, you and you.
Thank you.
We are together. I'll be here with you till the afternoon, no problem.
So my question is, realistically, how can African countries achieve industrialization and poverty reduction at the same time we are applying the same climate restriction as the countries who have developed through industrialization and a lot of emissions? So how can we balance that? We want to get over poverty because most African countries are poor. How can we do that at the same time we're applying the same climate restrictions as the countries who have already developed?
Thank you so much. This is the aim of the exercise tomorrow, how to make the balance between the development and protecting the environment. I will just give you the example of Singapore, of all these tigers, you know, from Asia, who came from nowhere with nothing. So poverty, we are not poor. If you have Tanzanite here everywhere. We are really a very powerful continent, and we are not poor. It's about good or bad governance. It's about how we can balance, how we can give opportunity to youth, how to empower women, etc. So this is also political side. And the issue of environment is not very difficult. Even when I go to Europe, the east of Europe one day was poor. So that we have to integrate themselves to Europe as European Union. They've done a lot of concessions, and they are very, you know, they overall all the challenges just by being inspired by the other experiences. So if we just open our eyes very bigly, and it's very easy to go on YouTube and to see how you can manage myself, yourself. We go to the supermarket and we'll find a product which is double price, but in it, there is a packaging saying that this is a cartoon that can be, comment on dit ça? Convertible. It will not pollute the environment. Or this product is coming, the plant, with no pesticide. It is 100% bio. For me, I will take it. It is for me better to put twice the price, and I have health. You know, I'm healthy, and I'm respecting the how to say, the environment. You see, it's all how you are putting your product and how you are doing your campaign. And in the meanwhile, technologies are not secret. I think now our people can go to Germany, to China, they have the skills, the knowledge, and come back and inspire their own government. So all these issues are not something difficult or impossible. The example of Morocco, of Egypt, of South Africa, of Kenya, of Nigeria, they are very, very advanced in a lot of things, you know. So I do not see any challenge. It's just about political will, giving priority, having this balance, fighting corruption, having national commissions who are doing the work with diligence, and having this understanding that this world, you know, it's evaluating too much, and if you do not care about environment, I think the future generation will pay. And I'm seeing a lot of documentary everywhere in our countries that are very dangerous. They are giving us alarm. It's threatening in all, I'm sure, in your countries, in your towns, at least in mine, I know a lot of towns who are doing noise, putting documentaries on record, doing things in front of the parliament, going and putting letters to the President of the Republic, speaking about pollution, etc., etc. So these things are not impossible to be done. And I think tomorrow I will see the skills and the innovative way you will defend the case and how we'll put in balance the two things. But for me, it's feasible. It's not impossible, something that we can care about, and it is really something feasible. I think you need to take the floor. Quickly, please.
Thank you, Professor. I'm also from Tanzania, and I should congratulate you for your African stand. We normally see in World Cup, sometimes when Morocco is doing well, it finds itself not to be an African country. So that's very good. Congratulations for that. I'm also very much impressed by your clarion call on the African voice. I've taught environmental law for almost 2 decades. And our starting point has always been the West. For instance, if our position is that environmental law is a new subject which started in 1960s. And as my brother said here, we trace it from the US, Rachel Carson's book, Silent Spring, also legislative. We take the Environmental Protection Act, 1969, which brought about EIA. But today, I've been very happy to learn that Africa in 1968 was ahead. The African Convention on Conservation of Nature and Natural Resources had provision, even if they're not detailed, even before the US. So, and right now, we have so many scholars, so many academicians of environmental law, but there are no many books written by African scholars, so we rely in international law as well as in international environmental law on Western academicians. So what is the problem? Why are we not writing books? It's- But you are also excellent. You are superb. So why generally, why are African scholars in environmental law not writing books on the subject matter? Thank you.
No, want me to speak? Oh, thanks, Prof. Well, now you are giving me a chance. I need to speak. Yeah. What I was just trying to make a comment that these academicians they be very careful about the political muscles. They should not play with the political muscle. I know there is an Iranian professor in the U.S. who was commenting the war between the U.S. and Iran recently, and he was evacuated from the U.S. So I advise myself and the entire room that we as human beings, we are political creature. And the politics is about who gets what, when, why, and how. So you need to, although we are being taught here all those things, but we have to use our common sense. Nobody who has a political power or political muscle who is very strong, you cannot play with the system. So I take a note of one of the professor in Dodoma was delivering a lecture about these movements and the other stuff, but he ended up to be regarded as a terrorist. So nobody who is in power can allow someone to play with his power. And take note of that politics is part and parcel of human life. It's just like water. If you take in the morning, you take in the afternoon. If you take in the afternoon, you take in the evening. If you don't take in the evening, you have to take shower and to wash your clothes. So you cannot live this world without politics. It is time immemorial, so we need to understand that one. We have all our academics and other skills, but we need to integrate these things. Thank you very much. You need to be safe. Yeah.
In addition to that, yes, please. Thank you, my brother, but I beg to differ. Our societies, as democratic societies, they should be based on the rule of law and adherence to law. No one is above the law. Even the head of state is not above the law. And we have had head of state who went from the state house to prisons, including Sisi, including Morsi in Egypt. So basically, our aspiration, our norm should be the rule of law.
We can spend hours on this topic, but thank you so much for transparency and for respecting each other. And we are here together. We all speak the same language and we respect each other. And all this will inspire us in a way or in another. Please, the one who represents the judge, stand up so that everyone see. She's representing the judge group. Who is representing the government lawyers? Stand up so that everyone see you. Okay. And no problem. So the one who needs to work with him and who will represent the civil society and environmental lawyers, you are the one. Stand up. So that you can see these are the focal points. And we have the CNN reporter, she's there. So please, everyone divide yourself. It will be short, not very long one. But simulation is nice and competition is nice. And this is how we educate people through the case law. Clinical law is very, very important. So I know that, take it as a joke, we're just gaming. It is not something very serious, but I'm sure that it can give you a good idea about your potentials and how you can be inspireful persons, because myself, I was inspired by the first group, as I'm saying in my writing, and you can go through it so that you can understand what I'm speaking about. When you have time, go to Vanuatu, on ICJ and see the lady, how she built the case in front of the ICJ. Also, this can be another component of the skills. And I will do some observation, because here it is not only about knowledge, it's about the whole. We are trying also to give recommendation to people on how to be a speaker in the group, how to be a leader, how to do the things differently, how to be impactful, how to have the right connection and networking. Everything cares. It's not about your CV, only about your knowledge and diplomas. It's about all this plus value that you have during summer camps, while people are in India or in New York or whatever. You are here doing the work, and you are caring about your future and your professional skills. And I really am very proud of all of you, and thank you for accepting to be part of this academy for the second edition. I think you have some announcements. I finish. Please do.
You're done? Okay, thank you, Professor. So a big applause to Professor. Thank you so much, Prof, for that valuable presentation. And I think we all agree that we are most interested in these environmental issues. So tomorrow we will be adding all the comments and reflection that we have during the group work. So as we are running out of time, I think that we are now denying you to the right of break. With not having a break, because there is another presentation we want to jump in now. I don't just know if you could just maybe stand up and brief. Yeah, to stretch, but not 10 or more than 5 minutes. Thank you so much.